I am John Dennis Smith, a barrister at 39 Essex Street Chambers, practicing in commercial and construction law. This podcast covers the continuing saga of the courts wrestling with the new rules governing how they should deal with non-compliance by parties with court rules and orders. In particular, it deals with the recent Court of Appeal decision in Denton versus T.H. White and two other appeals, which are the subject of a judgment handed down on the 4th of July 2014. There has been considerable discussion, even controversy, concerning the Court of Appeal decision in Mitchell versus News Group newspapers. The facts set out on the slide concerned non-compliance with cost budgeting rules, CPR rules 3.13 and 3.14, which set out a clear deadline and a clear draconian sanction for non-compliance. As summarised on this slide, the claimant did not apply for an extension of time for compliance, failed to comply, and the Court of Appeal refused an appeal from a decision to refuse relief. In practice, the claimant is going to recover very little of his costs, even if successful. The basic rule governing relief from sanctions is on the screen. On an application for relief from any sanction imposed for failure to comply with any rule, practice, direction or court order, the court will consider all the circumstances of the case so as to enable it to deal justly with the application, including the need, A, for litigation to be conducted efficiently and at proportionate cost, and B, to enforce compliance with rules, practice, directions and orders. An application for relief must be supported by evidence. Formerly, there was a checklist of factors to be applied, but it was felt that this was leading to a formulaic approach. Now, there is no checklist, but note those two provisions A and B. They will become important later. You need to read the full judgment in any case, but that is particularly important in Mitchell because the tone is striking in its criticism of non-compliance with rules and orders. However, the key passage concerning the approach to take is at paragraphs 40 to 41. It will usually be appropriate to start by considering the nature of the non-compliance with the relevant rule, practice, direction or court order. If this can properly be regarded as trivial, the court will usually grant relief, provided that an application is made promptly. If the non-compliance cannot be characterised as trivial, then the burden is on the defaulting party to persuade the court to grant relief. The court will want to consider why the default occurred. If there is a good reason for it, the court will be likely to decide that relief should be granted. But mere overlooking a deadline, whether on account of overwork or otherwise, is unlikely to be a good reason. Mitchell gave rise to at least three important questions. How does one decide what is trivial and what is significant? How important is whether prejudice results from non-compliance to the other party? How important is compliance for compliance's sake? In Denton, the Court of Appeal heard appeals in three cases. The Court of Appeal did not say that Mitchell was wrongly decided. The members of the panel stated it had been misunderstood. The majority, Lord Dyson, Master of the Rolls, and Lord Justice Vose, stated a new test. The court should identify and assess the seriousness or significance of the failure to comply with any rule, practice, direction or court order which engages CPR Rule 3.9. The court should consider why the default occurred, whether for a good or bad reason. The court should consider all the circumstances of the case so as to enable the court to deal justly with the application, giving particular weight to the factors set out in CPR 3.91a and 1b. Lord Justice Jackson dissented from that last section. He agreed with all but the weight to be given to the factors set out in CPR 3.9a and b. He held at paragraph 85 that those factors must always be considered, but not given more weight than any other factor. All the factors have to be considered. So what does this mean? Mitchell has not been overruled. The examples given in it are paragraph 41 of what might be a good reason or bad reasons for non-compliance remain valid. However, the tone of the judgment in Denton is very different from that in Mitchell. There is a sense that Mitchell has been misunderstood. See paragraph 37, in which the majority held, "We are concerned that some judges are adopting an unreasonable approach to Rule 3.91. Moreover, the fact that the Court of Appeal did not refer to any other post-Mitchell decisions suggests that one needs to be careful before one refers to them. At the very least, one will need to reframe those decisions within the new test." The majority at paragraph 38 emphasised that relief can be granted even where the default was not trivial or there was no good reason for it. To that extent, Denton does seem to be a relaxation from the Mitchell approach. There are, however, problems. First, there is the dissent from Lord Justice Jackson. The majority held that the two factors stated in Rule 3.9a and b must always be given particular weight to avoid slipping back to the pre-Jackson report culture of non-compliance. Lord Justice Jackson himself felt this was going too far. He considered that while his test would have achieved the same result in the free appeals as that of the majority, in future the two tests may lead to a different result. It is quite alarming to see the majority of the Court of Appeal quoting back to Lord Justice Jackson passages from his own report to tell him that he is wrong. Second, how important will proving prejudice be? Put another way, in paragraph 25, the majority held that the court should identify and assess the seriousness or significance of the default, but at paragraph 26 referred to the need to assess its seriousness and significance. Is there a difference? Is seriousness a matter of how flagrant the breach was, and significance a matter of its impact? The majority at paragraph 26 seemed to suggest that a breach, such as not paying court fees, could be serious without being significant because it may not affect the efficient progress of the litigation. They expressly left it to future courts to provide consistency. Lord Justice Jackson referred critically at paragraph 91 to the fact that non-compliance may have a serious impact on opposing parties. Does non-compliance have to have a serious impact before amounting to a serious breach? Third, what is the test governing the application for an extension of time, which is what the party in difficulty should be making? The Court of Appeal in Denton simply referred to an earlier Court of Appeal judgment handed down on the 19th of May 2014 in Hallam Estates Limited versus Baker, 2014, EWCA CIV 661, in which the Court of Appeal held that the Mitchell criteria do not apply to in-time applications for extensions of time, and that the approach to be taken in those circumstances remains as set out in the Court of Appeal decision in Robert versus Momentum Services Limited, 2003, EWCA CIV 299. That case, however, did not purport to set out complete guidance as to the correct approach. The Court of Appeal in Robert versus Momentum Services instead took a more limited approach, rejecting two reasons given by the judge below for setting aside a district judge's decision and thus restoring that decision. In Hallam Estates, Jackson, who gave the leading judgment, referred to the overriding objective, which CPR Rule 1.2 mandates must be considered whenever the court's powers are applied. Further, he commented that the claimants made a reasonable application for an extension of time which did not imperil any future hearing dates or otherwise disrupt the proceedings. That may accord with his approach in Denton as to what the approach should be under CPR 3.9, but of course the majority in Denton did not agree. It would have helped to have had more guidance as to how different the test governing extension should be from the test governing relief from sanctions. So what should parties do? The safest approach is that a party in difficulty in terms of potential non-compliance should still seek to avoid default by seeking an extension of time. It should focus on when extension would not cause prejudice or the postponement of a hearing. The party anticipating non-compliance by another party should do two things. First, it must pay heed to the warning given in Denton at paragraphs 42 to 43 by the majority that no party should seek to take advantage of another's mistake in the hope that relief will be refused. The court warns that, as contemplated by the new rule CPR 3.84, parties should be ready to agree limited extensions of up to 28 days. Opportunism shall be penalised in costs. Second, if it anticipates that it is going to oppose an extension of time or the grant of relief, it needs to foreshadow in correspondence factors on which it may rely and to seek to close off avenues. For example, by identifying the deadline dates in advance so as to be able to point to any missed opportunity by the party in default to seek to agree an extension. It would need to show that it's not taking technical objections. One can imagine the party in that position providing more information than it would normally do, for example, concerning availability of expert witnesses, to explain why it's not possible to postpone steps in the court timetable. In conclusion, we had Mitchell, and now we have Mitchell and Denton. There is no doubt that the emphasis has changed, but we do not yet have clear dividing lines that provide certainty as to how CPR Rule 3.9 is going to be interpreted. We are going to have to pay attention to more decisions along the way.